deal with here. Hey, don't tell them that we're ready.
An appeal in the matter of PRA Group UK Limited and Goodinson.
Yes. My lords and my lady, yes, I appear on behalf of the appellant in this matter. My junior for today is Miss Connolly, who sits behind me. Mr. Jones, you see, and Mr. Mantle appear on behalf of the respondent. In terms of the running order for the day, my lords and my lady, we're dealing with the application this morning, which is an application for permission first to amend the skeleton argument which has previously been submitted to deal with reconstitution, and secondly the evidence which has been submitted and will be dealt with by my learned friend Miss Connolly.
Yes.
And then in the afternoon we have the submissions in relation to the main appeal itself.
Well, we need to decide the application to adduce fresh evidence at the start, really.
Yes.
Shouldn't have thought myself it will take all morning, but let's see how we go.
Indeed, Lord. The application has two parts, one of which is an amended skeleton argument. It may be useful for...
Well, isn't that consequential? I mean, we're usually fairly relaxed about amended or refreshed skeleton arguments, but if we allow the fresh evidence in, then obviously it would follow that you need the amended skeleton argument, and so does Mr. Jones in replying. If we refuse the fresh evidence, then is there anything in the amended skeleton argument for which you need leave? Wouldn't have thought so.
My lord, it's simply the issue on reconstitution, which in our submission has been raised at a very late stage after the trial below. So my amended skeleton argument deals with reconstitution, which was not an issue at the first trial, indicating that it's not going to be problematic to rely on that in any event, regardless of the outcome of the application, the evidence. Then I need to make no further submissions on that. But the amended skeleton argument is all about the reconstitution. It may be helpful to take your lordships through the change in case, which we submit has happened at this stage.
Yeah. Mr. Jones, anything on the, as it were, the agenda?
Lord, no. I'd have thought it sensible, if I may say so, to go first of all with the application in respect of evidence, because we're not quite sure were this court to allow it, where that takes us, who's going to assess the implications and so on. So there's that. In terms of the Reconstitution, as it's called, well, as you'll appreciate, having read the papers, there's a bit of something of a dispute about that, because we say it's plain from the off there was Reconstitution, it's in all the transcripts. But I'd have thought, if I may say so, the obvious thing to do is take first of all the application in respect of the evidence.
Well, let's do that. Let's Mr. Brennan, you make your application to produce fresh evidence, then we'll at least come to a decision on that, and then we'll see where we go from there.
Thank you, my Lord. If it please your Lordships and your Ladyship, my learned friend Miss Connolly will be dealing with the application for the fresh evidence.
All right. Well, by all means, Mr. Brennan, you sit down and let Miss Connolly get on with it.
Is that?
My lords and my lady, this is the Appellate's application permission to rely on fresh evidence. May I ask if you read the skeleton argument?
Yes.
Do you need me to go through it in detail? Or
Well, you do as you think best, Miss Connolly. You know more about the case than we do. We've got the amended appeal skeleton for the appellant and the separate appellant skeleton argument in support of the ancillary application, and we've read both.
The respondent and the appeal skeleton argument before this court has changed position on the default notice in question, and now asserts it as a reconstitution. In the court below, the respondent pleaded in its particular claim that the default notice in question in this appeal was a copy. The respondent's disclosure is dated 15th of November 2018 certified as having its possession the default notice. In oral submissions before Deputy District Judge Simpson, counsel and respondent referred to the default notice as a reprint. The respondent's before Deputy District Judge Simpson, which was on Judge Clarke, contained no submissions on the default notice being a reconstitution. Lord Justice Arnold, by his order granting permission to appeal the order of Her Honour Judge Clarke to the Court of Appeal, allowed permission to widen the scope of the appeal. Permission was granted as the appeal raised an important principle or practice that to the extent to which the existence of a compliant statutory notice can be inferred, and the parties were also directed to consider the best evidence rule if and to the extent that it still survives. The principles relevant to the applications to introduce fresh evidence on an appeal are not controversial.
No, and you don't need to read out the bit about Loud and Marshall, Miss Connolly. We do know about that.
I'm grateful. And the new point of appeal was recently considered by the Court of Appeal in Notting Hill Finance Limited v. Shea, which depends on analysis of all the relevant factors, although the court should always be cautious in granting permission. But generally a new point should not be permitted if either, one, it would necessitate new evidence, or two, if it had been raised below, the trial would have been conducted differently with regard to the evidence, and or would require further factual inquiry. It is the respondent in our submission who is raising a new point of fact on appeal as to oppose to a point of law. And even if an application had been made by the respondent in respect of reconstitution, we submit it falls foul of both considerations 1 and 2 in Notting Hill Finance.
Ms. Connolly, what do you say about paragraph 4 of Judge Melissa Clarke's judgment? Page 40 of the core bundle. This is where she said that the primary submission made by Mr. Brennan Banks to her was that the Deputy District Judge couldn't properly assess and make findings on the validity of the default notice because he had no such notice before him, and that the judge had accepted that the document in the trial bundle was a reconstituted letter.
Yes, sir, but it was not the case as pleaded by the respondent.
It was your case. It was your case.
No, in the trial below.
But this is an appeal from Judge Clarke.
Yes, but the reconstitution point was at the trial below, before Deputy District Judge Simpson, my lord, right up to the trial, the respondent's position was that the default notice in question was a copy. The issue of reconstitution had been flagged in the request for information that the claimant made to us on the issue of the default, the credit agreement, which was pleaded in the defence as being a reconstitution. But at no point did the claimant advise us that the default notice on which they were relying was a reconstitution.
Are you saying you didn't know that?
They were saying it was a copy.
Are you saying you didn't know that?
It was the default notice they were relying on.
But I'm just looking at paragraph 14 of the Deputy District Judge's judgment. He says it is obviously a reconstituted letter. As I read the judgment of the Deputy District Judge, it all proceeded on the agreed footing. It was obviously not the original document or a copy of the original, but I may have misunderstood that.
I was not actually physically present at that hearing, my lord, but my learned friend was, and may be able to assist you on that point.
But do you have a submission to make about whether, on your side, you proceeded before the Deputy District Judge on the mistaken understanding that this document was in fact not a reconstituted document, but some sort of copy?
Yes.
My lord, if I may, it may be useful on that point, just to see the documentation itself, to see what we were dealing with at the original trial.
Well, I mean, the question here is whether you were taken by surprise by a new case that you didn't.
Well, yes, because the pleading case
hadn't foreseen or didn't understand when it was presented.
Yes, my lord. We conducted the case as it was a copy of, as was said in the particular claim, in the reply, and in latest Part 18 replies as well, that this was a copy. So we turned up at court to deal with a copy of the default notice, and we could see that.
Well, what do you mean a copy? Photocopy?
Precisely, my lord. It wasn't, at no point during the pleadings is it ever been suggested, at any point, that this was a reconstitution. And a reconstitution gives rise to a whole plethora of questions which we never had an opportunity to put forward to the judge in the original trial. And the only reason why reconstitution came up is because I offered it as an explanation as to why this is clearly not a copy of the default notice. If I may take your lordships to the core bundle and show the references where all we're dealing with is a copy, as opposed to a reconstitution. When a reconstitution means it's been made up, it's been created by someone at a different date, and we don't know by whom, we don't know when it was created, for what purposes, we don't know where the information came from, we don't know what manual inputs.
Yeah, but you're getting into submissions on the merits. At the moment, seems to me, the Deputy District Judge, as my lord has referred you both to, says it's obviously a reconstituted letter. There's then an appeal to Judge Clarke, who says the same thing. Lord Justice Arnold gives permission to appeal to this court on the same basis, that it raises a point of principle, and you're giving us a foretaste of the argument on the point of principle. If it is a reconstituted document, is that enough, or does the finance company have to produce the original? I don't understand the proposition that you were taken by surprise, and therefore the whole thing has gone off on a false basis. If that's so, we shouldn't be here.
Well, my lords, in support of the application itself, we're saying that we haven't had a second bite of the cherry, which is one of the concerns, is that we should have produced the evidence before. But we never had an opportunity to have a first bite of the cherry because we never were able to make any questions about this issue because it was never put to us as a reconstitution. I appreciate that this is perhaps slightly wider than the appeal that's being heard today, but it is in support of the application because the issue of reconstitution was never dealt with properly in the first hearing because it was not in the particulars of claim.
But why didn't you raise it as a ground of appeal to Her Honour Judge Melissa Clarke?
We only had permission, Your Ladyship, on ground 3 at the end of that appeal. And the issue of reconstitution, again, it didn't appear in the respondent's notice. And I tried to tackle that during submissions with...
Sorry, so did you raise it as a ground of appeal and then not get permission for it?
Not specifically that this wasn't a reconstitution. We didn't appeal on that point, but it was just part of the submissions. You cannot rely on the documentation that was provided because it's not a copy.
But if you were taken by surprise when you got the decision of the district judge, why didn't you appeal to the circuit judge on the basis that we never realised it was a reconstituted document, we were never told this, and that's unfair? I mean, there's no trace of that argument having been raised with the circuit judge.
Your Ladyship, the arguments being put forward by the respondent today is essentially that it's not a problem that you can reconstitute documents under the Consumer Credit Act. It's part of their...
But that was the approach of the district judge. So if you were concerned about that, I mean, you could see on the face of his decision that was his approach. If you were concerned about that, why didn't you appeal on that basis?
It was collectively within the appeal on grounds 3. We were dealing with the issue. We may just turn to the grounds of appeal for Judge Clarke. Well, tab 1 of the core bundle, we have our grounds of appeal. And the issue that was being raised was about compliance, which is at paragraph 4. So this is page 12, tab 1.
This is the appeal to us. What my lady was asking about was the appeal from the district judge to Judge Clarke. We have got the skeleton on behalf of your client in the county court before Judge Clarke, and it seems that there was an application before her to admit new evidence.
Yes, my lord, there was an application there to admit new evidence. The evidence that's being requested today includes documentation which wasn't there, wasn't part of that application. There is some documentation which is part of that application, but where it is new evidence, we submit that evidence should be accepted because the issue of reconstitution and the assumptions of the basis of the decision were never raised by the claimant in these proceedings, and they weren't raised on appeal in a respondent's notice by the claimant either. And the first time the mention of reconstitution comes up from the claimant was during Mr. Mantle's submissions in reply to Her Honour Judge Clarke. So we were dealing with at all stages that this is just simply a copy.
But I just don't understand that submission because it's clear from the district judge's decision that he thought it was a reconstituted document. So if you thought that was wrong or it was unfair for him to reach that conclusion, Why didn't you challenge that on your appeal to the circuit judge?
That wasn't a specific ground of appeal, but it was in discussions, formed part of our appeal to the circuit judge, because we were talking about the paucity of documents, the inferences that were made as a result.
You say, look at tab 7, page 50. It says that the judge, that's the Deputy District Judge, correctly identified that the document was not a copy of the default notice. There is no such thing as a reconstituted default notice, or that's an argument of law. And we've only got to decide that.
Well, Lord, I submit that the grounds of appeal which were brought before this court encompasses that issue as well, the issue of reconstitution. There was only upon a fine reading of all of the transcripts of the proceedings below that it realised that there was, the first time it's mentioned is obviously in reply in the appeal. So we now find ourselves in a situation where the case as it was run was substantially different to what we now face in terms of...
I thought your point was a point of law. It has to be a point of law as to what the Deputy District Judge was or wasn't entitled to do.
Yes.
And you've encapsulated in your grounds that he wasn't entitled to proceed in the absence of a copy, or no doubt the original, of the default notice.
Yes, ma'am.
Well, it's common ground. It was common ground below, as far as I can see, that he didn't have anything that was the original or a copy. But he had a reconstituted document. So why does it matter what happened in other cases, or whatever other evidence you might adduce about other cases?
My learned friend will deal with those submissions at that particular point, but generally the issue is, what are the consequences of upholding the decision of the court below? And the consequences are that a claimant in these types of matters doesn't have to produce evidence of their cause of action.
But the point of law can't depend on the consequences. It's either a good point of law or it's a bad one.
But, my Lord, when we're looking at considering the impact of the case and the policy of this case, I would submit that actually what does happen in other cases, what happens on a regular basis, is something to be borne in mind as to the construction of the evidence rules in relation to what has to be before a judge or not. And so what we're seeking today, my lords and my lady, is a clear decision for guidance, essentially, for the county courts, judges, that when they're faced with what are said to be reconstituted documents, that they can't be relied upon.
Yes. Well, that is indeed the point we have to decide. But why will even if you were able to get over the Ladd-Marshall criteria, why does it matter how much of this is going on?
My lords, it's pretty fundamental to the way the courts are run that there is a fairness, the overriding objective of fairness between the parties. If one party, the claimant, doesn't have to provide their evidence, or doesn't have to provide the correct evidence, and judges can then go around inferring the existence of statutory documents left from just random numbers, then that will open effectively the floodgates for...
But suppose a witness was called who said, I remember vividly creating this document. I remember how I did it, that I followed precisely every step of the way the statutory provisions. And I signed it and I put it in a document, in an envelope, and I wrote down in my own hand a detailed account of what I'd just done. But now we lost the document. Is it your case that the judge couldn't accept that evidence as sufficient to establish compliance with the statutory provisions?
Well, that would entirely depend, my lord, upon the contents of that witness.
Yeah, well, that's the point. If it depends on the evidence in the case, then it's not a point of law.
My submission is it can't be accepted unless it shows what was originally sent, because there's...
I understand that. That's the point of law. If you win on the point of law, then that's the end of the case, isn't it? we're still on a preliminary issue. The trial has not taken place. That's right, isn't it?
The trial was adjourned, part heard. It was part heard on this one issue.
All right. Okay. But if you're right that production of the original, or at least a photocopy of the original, is essential to the cause of action, then your appeal is allowed, and that's probably the end of this case. If you're wrong, then the trial resumes, part heard. But why is fresh evidence going to help about?
Well, Lords, my lady, it's to confirm what is actually happening in practice, what is happening in the courts below, where there is no reliance on that original. And the problem, as I mentioned earlier, is the floodgates. What is it if the judgment is upheld from below? Then we're giving wide scope to claimants to no longer provide the documents they say they have in their possession, but rely on something else. And that's the problem in this case.
But that's obvious from the way in which the point of law is framed. I don't see how we're helped by a mass of evidence about other cases.
My lady, it's also this respondent, PRA group.
But again, the same point applies, doesn't it?
It's an indication of the dangers that arise as a result of upholding the decision below.
But aren't those self-evident?
If they are self-evident to the court, then I submit that perhaps it is not required to include all of the evidence, but that would be putting the cart before the horse, because obviously we're making the determination submissions about the core legal principle after this application. It may be useful for my learned friends to address the court on the issue of this fresh evidence and the amount of work that was done to collect this evidence. It just shows what's happening in practice. And
but if the evidence doesn't pass the test in Land and Marshall, the amount of time it's taken to collect it is neither here nor there. I mean, the key thing, does it pass the test in Land and Marshall? Surely.
And in particular, Mr. Jones, let me assume in your favour that that there was a good reason why your client didn't adduce this evidence before the Deputy District Judge. Assume that the evidence couldn't have been obtained with reasonable diligence for use at the trial because you weren't expecting, you read the pleadings carefully and your side weren't expecting the point to be put like this. But you or Miss Connolly have still got to persuade us that the evidence, if given, would probably have an important influence on the result, i.e. that it, you say, look at this evidence, it will induce you to decide the point of law a different way. I don't see at the moment, I mean, your argument on the point of law may be a good one or a bad one, but at the moment I don't understand why it gets better if the fresh evidence is adduced.
My lord, that's actually addressed in the judgment of Honour Judge Clarke, which is in the core bundle at tab 6, and this is why I draw your lordship's and your ladyship's attention to it. At tab 6, page 44, and there seems to be the reason why part of the evidence is being put forward in the application today. Paragraph 18 at the bottom, Honour Judge Clarke states, "It seems to me the requirements of the CCA, the Consumer Credit Act, were well known at this stage. The prescribed warnings had been needed for many years. MBNA were a large credit card provider at the time with many customers, and the same prescribed wording would have been required on every default notice." And what's happening here in my submission is that Honour Judge Clarke is making an assumption, essentially, about compliance, because it's a large institution, they know what they're doing, and so we can assume compliance. And this is a very slippery slope in my submission. Because that assumption is incorrect. And all of the evidence is addressed towards that very point. The assumption that informed Your Honour Judge Clarke that everything was acceptable to infer the existence of a document which wasn't before the court. And the content.
She's talking about a different point there. She's talking about what wording would have been in the notice, isn't she?
But she's mentioning the prescribed wording in that, but of course we didn't have a copy of the prescribed wording for the court.
No.
Which is the issue.
But all that's just by way of introduction to her conclusion that it was open to the DDJ drawn inference that the notice of default was created and sent on the 3rd of December.
Well,
and was on the balance of probabilities otherwise compliant, given the evidence before him. And she goes on to say it's not an inference every judge would make, but it was open to him.
well, my submission is in law it wasn't open to the judge, Deputy District Judge.
But that's a different point.
But also in terms, my lady, in terms of the evidence, that assumption, the underlying assumption of regularity cannot be relied upon, which is why it's so important for the claimant to actually prove their case rather than making broad assertions.
But what did the DDJ? Did the DDJ make such a broad assumption, or did he simply deal with the facts before him?
In terms of the judgment of Deputy District Judge Simpson, which is tab 9. In terms of the assumptions, because there was no argument about this reconstitution, at paragraph 19 of the judgment, page 60, where the Deputy District Judge Simpson is talking about the archive records from which his decision is based, those letters. And in the second sentence, Deputy District Judge Simpson says, "I previously asked what differences were between the customer information log and the archive log, but neither counsel could assist." And he goes on to provide an explanation. But this is the difficulty, is that we're dealing with archive records, and neither party is able to substantially say to the court what they actually mean and what they are.
But that's a different point, isn't it? My lady was asking you about the paragraph that you focused in on as a justification for the application to adduce additional evidence. And for my part, it seems to me that what you're really saying is that you want to amend your grounds of appeal, because the proposition that you put to us, that the slippery slope of assumption in paragraph 18 is very dangerous and incorrect, and that the evidence goes to that, doesn't seem to me to marry up with the grounds of appeal which you put forward and for which you've got permission.
I see the point, Lord. The evidence is in support of the legal principle, and that's my submission on that, is that this evidence shows that slippery slope and what the consequences are.
But to go back to the question I asked you, what the Deputy District Judge does in his judgment is to look at the material that the parties were able to put in front of him very carefully indeed, and to draw inferences from that material. I hadn't picked up on my reading of his decision that he'd made any presumption of regularity at all. That's why I was asking you the question. Where does he make a presumption of? Where is there evidence of a presumption of regularity?
Well, this is dealt with, again, at the same judgment at page 60, paragraph 23. This is where, in my submission, the assumption is put in, or is referred to by the judge. It's the third line down in paragraph 23, page 60. Pausing there, I have had no issues raised today in relation to the prescribed form of the notice dated 3rd of December 2012, And so as a result of that, which is an incorrect finding, the judge then goes on to say that, assume that it was compliant, because there was no wording before him to assess compliance.
Well, we know that. I mean, he goes on to make findings at 33, 34, 35.
Yes.
He accepts the logs are a contemporaneous record, and he's satisfied on the balance of probabilities that the default notice at page 284 was created on that date and contains the information. Now, I quite understand the point of law that you say that that's not good enough as a matter of law. But isn't that the point we have to decide, whether that's good enough as a matter of law?
Yes, my lord, that is the core issue that needs to be determined in the main appeal. My submission is that there was a genuine concern that there would be a presumption of regularity when one makes reference, as happened in this case, to a line of letters and numbers. That in and of itself suggests that something has been created, something has been sent, and that it's compliant. I mean, it's the whole logic that underpins the judgment of Deputy Chief Judge Simpson. And therefore, the evidence that we're relying on, requesting to be admitted, shows that that assumption is those assumptions underlying his judgment are incorrect, clearly incorrect, and not just with this individual respondent, but with the wider industry.
But the issue is what happened in this case, not what happened in other cases. Was the evidence in this case sufficient to satisfy the district judge that the default notice was sent in a compliant form on 3rd of December 2012?
I appreciate it's a relatively straightforward point, and one would hope that the conclusion would logically follow from my submissions in my main appeal skeleton argument. If I may just take instructions, just
yes.
very briefly.
Yes.
My lords, one of the main issues relating to the evidence is what happens during the reconstitution process. And that evidence is important because essentially the court will be assessing whether, or deciding whether reconstitutions are acceptable or not. And without a factual matrix, it may be difficult to see the implications.
This is obviously being fought as a test case on both sides, isn't it? And this isn't a sort of David and Goliath case. It's obviously of huge importance to PRA, but the bills of costs which were sent to us yesterday indicate that Miss Connolly has put in, what, 70,000–80,000 pounds worth of work on this case?
Much of which I believe relates to the process of gathering all this evidence in relation to the application.
This is in relation to a case where Mr. Goodinson is said to owe the finance company £17,000 odd, and the default notice, which they say they served, was that you must pay a minimum of under £3,000.
My lord, I completely accept that the costs and the court time that this case has taken up is disproportionate to the original claim valuation. But it's an important point, a very important point, because it is essentially, in my submission, the entire basis many debt purchasers, the entire basis of their modus operandi, how they actually act in practice, and that's the purpose of trying to reduce this evidence, to show what happens in practice. And so it's critical not just to PRA, but also other debt purchasers who may not have, for whatever reason, copies of the default notice, which is a basis of their claim. Unfortunately, most of these claims sent to consumers are not disputed.
That strikes me it's not a very good vehicle for the point, this case, not a very good vehicle for the point you're seeking to make. Because if you're right in saying that the district judge proceeded on the assumption of regularity that you point to in the judgment of Judge Clarke, that was a point that could and should have been taken on the appeal to Judge Clarke. To take it now, when as I read the documents, it wasn't taken before Judge Clarke and wasn't taken on this appeal until you made this application, is rather unsatisfactory if what you're seeking to do is to produce a guideline judgment.
One can only play the hand that is dealt. We don't get a chance to select the ideal
according to you,
case.
there are plenty of other cases in which the same point arises. I mean, your whole point is that every time this company, or as I understand it, any company, pursues a claim of this kind, the court should be alert to, either in some way, the unreliability of a reconstituted document. Wouldn't it be a better case to run that with the evidence in front of a DDJ the next time this issue arises, rather than have a first instance decision in the Court of Appeal when the case has gone off on a different basis in the two courts below?
Well, in response to that, my lord, this issue isn't going away. I know this may not be an ideal case. You never find the ideal case, but this issue is not going away. So it will come back, most likely, to this court at some point about the reconstitution. So the question is, does the court deal with it here now, when it has the opportunity to do so, whilst reviewing the evidence to show these unreliability of these assumptions, or does one just kick it down the can, leave consumers to try and deal with it themselves, and deal with it in 18 months, or however long it takes for it to come back here? So, my lords, the witness statement of Colin Quinn was also put in to the original court because it's adjourned part heard. And so we're submitting to the judge below that the unreliability of the documentation provided by PRA, and in fact the judge pretty much invited us to make that application for the additional evidence that need to be dealt with. So on that point,
but then isn't it much better that it should be evaluated at first instance in the context of a fact-finding exercise, which we're not here to do?
well, my lady, we obviously put in an application for fresh evidence to show the unreliability of the documentation and to show that these, before Her Honour Judge Clarke, so that was part of the appeal, is trying to submit this new evidence to show the unreliability of the presumption of regularity whenever dealing with a large bank. And so that was raised at the appeal below. Our submission is that because
So what did Her Honour Judge Clarke make of that?
it was refused, primarily on the basis that it could have been found previously, which is, it was in fact we have,
But you haven't appealed that decision?
no, we did not appeal that decision because the evidence has changed. And our submission is largely that because the best evidence rule has been invited in the order granting permission to parties to consider the best evidence rule. So now we were engaged with looking at the primary evidence, a copy, and secondary evidence, which is logs, etc., etc. And so that invitation to consider the best evidence, we're now showing the unreliability of secondary evidence on the basis of that invitation to consider that point, which both parties are trying to deal with. So my submission that the evidence has changed since the hearing for Honourable Judge Clarke. As in, we only put in narrow evidence for Honourable Judge Clarke, which was refused. This later witness statement of Mr. Quinn covers a wider scope, much wider scope, both for PRA and for other debt purchasers. And so the invitation from this court to deal with best evidence means inevitably, one I submit, that one has to consider what is the secondary evidence that we're talking about.
So the narrow evidence that was put in before her Honourable Judge Clarke, was that just evidence relating to this respondent, or was it, I mean, how did it differ in particular from what you're seeking to deduce now?
If I may turn to my learned friend to address that point, the difference between what was before Honourable Judge Clarke and what is before the court now.
Key differences between what was before Judge Clarke and now is that there were only 3 particular creditors notices looked at. In this case, we've exhibited templates for Halifax, for example, Halifax Bank, which the actual template wording the actual template is incorrect on the dating side. You can demonstrate that. So there's far more evidence here at the court today than there was before her Honourable Judge Clarke, because it wasn't easy to obtain. It wasn't reasonably obtained easily with reasonable diligence. But once we got the permission from Lord Arnold, and we realised the best evidence rule was being reviewed in relation to this in the area of the Constitution, we thought it would help the court, assist the court, if it had an indication that normal presumption of regularity where there's a big, large financial institution, just to show, also in effect to rebut the assumption of HHJ Clarke in judgment, where she said that MBNA were a large credit provider and the simplified wording would be used. Her Honour Judge Clarke didn't consider the fact that the actual wording on the template is only one aspect of compliance on that notice. The key aspect of compliance is the dating, the amount of time allowed for remedy of the breach, because the borrower is supposed to have 14 clear days under Section 88 B of the Consumer Credit Act. And if the template is wrong in that the dating that goes into it is wrong, you can't tell from a reconstituted document if the actual one that went out was correct. But if there's a presumption of regularity, because it's a bank like Halifax or MBNA or any bank, then the defendant is at a disadvantage, because the appellant's firm solicitors is only a small firm, and in dealing with the cases has gathered a bank of evidence, but not all cases were gone through. But the average consumer the claims are issued on bulk online. Default judgments are a high percentage of them, and then the consumers themselves generally don't understand the requirements of the Consumer Credit Act for compliance. So if, as some of this evidence shows, they get a solicitor's letter with a default notice, they're not going to know if it complies or not with the Act. And it is a primary protection in the Consumer Credit Act that the default notice is correct, and also gives all the prescribed warnings, but also allows the time. And although some of these, and the other thing that this evidence shows is that it's still got the evidence in this application goes from 2009 right up to 2019. So the default notices are still being done incorrectly in 2019, and in debt cases, these cases will keep coming up to the court, because if the debtor is making payment, a small monthly payment, action won't necessarily be taken straight away. And then eventually it gets signed off to a debt purchaser. And at that point, debt purchaser decides whether to issue or not, or wait for a limitation point if the debtor stops paying. But
Ms. Connolly, can I ask you this? Judge Clarke's judgment begins by saying, this is an extempore judgment determining the appeal on the single ground on which I've given permission to appeal. That's ground 3, whether or not the judge was correct to infer compliance with the notice. The notice of default he found had been created and sent, notwithstanding errors on its face. And she had apparently refused permission to appeal from the district judge on 3 other grounds. What were those?
There was. Can I assist the court? I'm trying to take
Yes.
the mask off. Try and assist the court. There was. I don't know if it reached you. There was, in fact, a copy of a judgment from
Yes.
Judge Clarke,
Yes,
which appeared somewhat late in the day.
just arrived.
If you, yes, I'm so sorry about that. But if you could go forward to page 3, paragraph 11. I think what had happened.
Not sure when it's
Sorry.
I've been going backwards and forwards between the paper and the electronic copy. Can you
Yes.
just
This was an
Yes, I'm so
attachment
sorry. I
to
think it
a
was delivered
separate email.
yesterday. It came in yesterday. It's dated 7th of February. Lady, do you have a copy of I?
I've definitely seen it, and I'm hoping it's in my clip of papers. Just checking.
Lord, have you got it?
I don't think I have a copy.
Right. Have we got a spare?
This is dated 7th of February, is that right?
7th of February.
Yes,
Seventh.
I have it, thank you.
Last year, yes.
You've got an unmarked copy. Thank you. Thank you. Would that help?
Yes, thank you.
Yes.
Thank you. I think what had happened, I wasn't there. What had happened, I think, was that Honourable Judge Clarke had refused permission, and then it was application was renewed for permission to appeal orally.
Yes.
And this is the
Yes.
ruling.
Yes.
And so I was going to
If
look at page 3,
if
paragraph
we
11.
actually had the
Yeah.
notice of appeal, it would all be a lot shorter. But what were the grounds on which she refused permission? Because on whatever they were, we have no jurisdiction to reopen.
Well, paragraph 12, first ground, in relation to the existence of a notice of default. That's paragraph 12. And she then goes on to deal with DDJ Simpson's specific finding, paragraph 31. The reconstituted default notice.
This is a document which we've all been referring to as a reconstitution.
Absolutely. Yeah, during the course of the transcript and elsewhere, reconstituted default notice, and she goes on. Well, I don't want to read it out loud.
No, please don't. So ground 1.
Paragraph 16. I disagree. It seems to be DDJ looks at the archive log, clearly has an experience looking at these documents, and a decision that was entirely open to him, cannot be satisfied any real prospect of arguing outside the wide ambit of determinations. That's paragraph 16.
Yeah. And then ground 2 is
ground
about the form of the document. And
and
ground 4 is the separate point about whether it's posted. And
Exactly.
that's one presumption which
Exactly. She seemed to run 2 and 3 together on the basis form had to be looked at. I think I'm right in saying. I think she says. little bit of overlap between what the form was and what the compliance of the notice of default was.
All right. Well, thank you.
Helps you.
We're in the same position as you, and we can read this. All right. Thank you very much. Now, Mr. Brennan, Miss Connolly. Incidentally, Mr. Brennan, you're down on the council slip as Mr. Brennan without Banks. You're down on the transcripts as Mr. Brennan Banks. Which do you prefer?
Brennan Banks. I got married at some point during these proceedings. My proper name is Mr. Brennan Banks.
Right. Congratulations. So, is there anything further that you or Miss Connolly wish to say on the application to adduce fresh evidence?
If I may just take brief
Of course.
My lords, my lady, we don't have any further submissions in relation to the evidence itself, save for the consideration I stated earlier about primary and secondary evidence, which is the value that can be attributed. And without a factual context, it's very difficult for the court to assess what this secondary evidence is or could be. In terms of the costs below, the costs of the application and the work that was done, we agree that it's disproportionate. It's just to show how much work was done and how impossible it is to expect solicitors to go looking through every single file they've got to check if there's any other issues which may raise in a current case. And that's the difficulty that we faced, is that HHJ Clarke said, you can't have this evidence, it seems to me that you had it in your possession beforehand. But that would imply a duty on solicitors to check all their files for other cases, which is prohibitively expensive and is unlikely to be approved by a court.
Right. Thank you very much.
Obliged. Thank you, Lordships, my ladyship.
We'll just retire at this point.
Guys.
We refuse the application to adduce fresh evidence. We will incorporate our reasons for that decision in our judgment, which will obviously be a reserved judgment at the end of the case. Right. Yes, Mr. Brendan-Max.
There is the remaining issue of the permission for the amended skeleton argument, which is required from the court, which deals with the reconstitution point. In terms of the amended...
Well, is this opposed? I would have thought that insofar as the skeleton refers to the fresh evidence, if it does, then we cross those bits out. But insofar as it doesn't, we should refer to it.
Yes,
Is that
of course.
Yes, right. Yes.
I'm obliged. My lords, my skeleton argument, or my amended skeleton argument, is contained within the application bundle, tab 8. My apologies. Amended skeleton argument is tab 5.
Yes.
Obliged, my lord. My principal submission is the grave lacuna within the law, which I set out paragraph 2 of my skeleton argument, which is allowing debt purchasers to ask a court to infer the existence of a crucial document, which is the default notice, without ever having to produce that document or test its compliance. Now that obviously denies important consumer protections which have been granted by Parliament. And more importantly, this lacuna would allow debt purchasers to avoid producing a statutory notice which they either know or have reason to believe is non-compliant, which would otherwise be fatal to their claims. I've set out at paragraph 4 and onwards the background to the case. I don't propose to enter into that in any great detail, unless your lordships wish me to go through the background for the benefit of those who are viewing.
Well, you set out the history in your skeleton, so no need to read that out.
Well, thank you, my lord. If your lordships and your ladyship can go to paragraph 7 of that skeleton.
Yes.
And the very last line, this is the basis of the decision of Deputy Judge Simpson. For those watching, it says NOD 150 BL 17480.71 AR 2904.79 SD 0312 DD 0512 EXP 2212. And that is the inference which Deputy District Judge based his decision upon, that there was an existing default notice and that it was compliant.
Yes.
Turning first to the ground 1, this is page 3, paragraph 10 of my skeleton.
Mr. Brennan-Max, I ought to know this, but I don't. At the hearing before the Deputy District Judge, did your client give evidence?
No. Nobody gave evidence for this point, which was addressed by the court. There were documents which were exhibited to a witness statement for a claimant, but in the application to adduce evidence at that stage, and it was properly pointed out by counsel Mr. Mantle that some of the contents of the witness statement were acceptable, and we said the same for their witness statement, because Mr. Glassborough was not an expert in this area and he had no knowledge of the documents for which to give evidence.
I haven't understood this. Which bits of your evidence were, as it were, admitted as read? I think that's what you've just said.
So it was the documents which were exhibited to the witness statement of Colin Quinn at the time, which was all the documentation which included archive records, etc. Those were the documents which are in the bundle, which the judge looked at and dealt with. So there was no witness evidence from either party.
Yes, so it's Mr. Quinn's document.
Yes, as well as some of the exhibits to the witness statement of Mr. Glassborough. So in essence, it was just a decision on the documentation that was available.
And there wasn't a witness statement from your client.
There was, as well as an application to rely on new evidence, which was at the original adjourned hearing, and that was refused, well, withdrawn. But simply the documentation was accepted by the court. So Deputy Judge Simpson was simply looking at documentation which was exhibited, but without reference to witness statements because nobody gave evidence. Well, ground one, the only ground really, compliance of default notice with the Consumer Credit Act. I think it's not really disputed between the parties that the sending and expiry of a default notice compliant with Section 87 and Section 88 of the 1974 Act is an essential element of the claimant's cause of action. And that was decided by this court in the case of PRA Group and Doyle, 2019. It is uncontentious in my submission, but if your lordships would like, no, I'm grateful for the indication. So the default notice doesn't just have to comply, obviously, with the Consumer Credit Act, it has to comply with the regulations attached to that, as set out in my skeleton argument. In my submission, given the strict requirements of both the Consumer Credit Act and the regulations that follow them, it was not open to the judge to dismiss our appeal because there was no copy of the default notice, any copy of the default notice, before the judge below. So there was no primary evidence, save for that long list of letters and numbers which I read out.
Yes. Is the position that if a default notice is not served and the finance company nevertheless terminates the agreement, they never get a second chance? The debt is just written off.
Yes, under the Consumer Credit Act, it's quite strict. There's no recourse if a court does not grant permission for an order, etc., or refuses a claim. There's no opportunity to come again because it's already been determined. So if they don't have the default notice, or don't have a copy of the default notice,
They can't start again with another default notice.
Well, in my submission, dealing with that, it would be re judicata. It's already been dealt with. Those matters between those parties on that fact has already been dealt with. And so they wouldn't be allowed to, in my submission, to bring a second claim on the basis of default notice, which is served subsequently, because it's already re judicata.
In relation to another default. I think that was the point my lord had in mind. Well, in this case, we've got potentially two defaults, one before the 6th of December and the other might have been afterwards. So suppose those facts. Would there be res judicata because there'd been an adverse finding on the first?
It's a little more complicated than that. You can only serve a default notice within 6 months of the default occurring. Now that's separate legislation. That's Data Protection Act and the Information Commission Act. So they must serve it within 6 months. So if they serve an invalid default notice at a specific point of time, and then, as PRA in this case try to do, serve it again in 2017, that's not valid. That's not a valid default notice.
So the debt is then effectively written off.
Effectively, yes. It
Yeah.
can be pursued as a matter of contract, but the Consumer Credit Act prevents that from happening because you cannot terminate the agreement unless there has been a default notice in cases of default. And that arises as a result of Section 87 of the Consumer Credit Act. Would it be helpful?
Yes, I think we probably ought to look at 87 and 88.
So, Consumer Credit Act is tab 1 of the Joint Authorities bundle. And this is something which this court considered in the case of PRA and Doyle. So, page 15 of that Authorities bundle is where we see Section 87,
Yes.
which is entitled Need for a Default Notice. And subsection 1 states, service of a notice on the debtor or hire in accordance with Section 88, the default notice, is necessary before the creditor or owner can become entitled, by reason of any breach of the debtor or hire of a regulated agreement, A, to terminate the agreement, B, to demand earlier payment of any sum, C, recover possession of any goods or land, D, treat any right conferred on the debtor or hirer by the agreement as terminated, restricted or deferred. So essentially it's a prohibition. And the default notice is essentially a way of telling the consumer what you've done wrong, what you need to do to put it right, and here's the wording to go with it, and here's a copy of the Office of Fair Trading at that time note to consumers. So without a default notice, if it's a case of default, you cannot terminate the agreement per Section 87. So, in effect, yes, the debt is written off in my submission. And it may seem harsh, but that is the process of the Consumer Credit Act. That's the intent of the Consumer Credit Act. If you don't do what is supposed to be done, then you cannot have recourse through an alternative method of civil claim. It must be compliant with Section 87. Section 88 for cases of default, which this case...
Yes, well, there's plenty of authority explaining why that's important.
Yes, well, I don't seek to take... the main paragraphs are 20 to 22 of PRA, paragraphs 20 to 22 of the case of PRA Group and Doyle, which is just for reference at tab 9. Unless your lordships and your ladyship wish me to take you to that judgment, I don't propose to make any further submissions on that if it's accepted by the court. That this is the absence of a default notice, compliant default notice, renders the claim dismissed or struck out.
Well, 87 is about service and 88 is about the content.
Yes, and yes, quite right, my lord. Just so we can reference it, it may be useful to, if your lordships wish to see the relevant paragraphs from PRA and Doyle, it's at tab 9.
Yes.
Paragraphs 20 to 22, page 166, in which all three counsel appeared in that matter as well. Do your lordships require a summary of the case? I'll invite your lordships just to read paragraphs 20 to 22. I hope that answers your lordship's and your ladyship's question about the consequences of failure to comply to 788, the Consumer Credit Act.
And perhaps you're right. I wish I was more familiar with this, but it doesn't seem to me to follow, obviously, from the wording, certainly of 87(1). You can't, if you haven't served a default notice, you can't terminate the agreement, right? You can't demand earlier payment of any sum, earlier than what?
So, for example, if one is making payments over a scheduled period,
Yeah.
and a default happens at, say, month 2,
Yeah.
they then make a demand for all the remaining.
Fine, but the it doesn't say that the sum becomes wholly irrecoverable forever.
It doesn't explicitly say that in the judgment, my lord, but that is there is various case law which was discussed in that case, and previous cases as well. Diamond and Lavelle from the House of Lords, as it was then, obviously where there was a claim for conversion under a Consumer Credit Act because someone taken a vehicle, and the lordship said quite clearly, apologies, not in the bundle because we're slightly straying from the original point, but there is no alternative route open to a creditor under the Consumer Credit Act. You can't use a tort of conversion, you can't use civil remedies. That is harsh, but that is the framing of the Act, and that's what it's supposed to do, is to ensure compliance, to protect consumers.
So it's an exclusive, exhaustive code of what the creditor can do and the conditions that need to be satisfied before the creditor can do those things.
Yes, where the sections apply, absolutely. I mean, there is, and my learned friend from the other side will no doubt point this out, if you've got a running consumer credit agreement which hasn't been in default, you don't need to serve a default notice. You do have a right to terminate, which normally runs when there are provisions for that within the Consumer Credit Act, which is section 1991, I believe, which is the need to send a termination notice. But essentially, the point is correct. Yes, the Consumer Credit Act prevents or closes certain doors that are open to a creditor in pursuing a debt if they don't comply with the Consumer Credit Act.
Right, thank you.
Returning to my skeleton argument, if I may. So we've seen paragraph 11. We've obviously seen there are strict requirements, and I'm happy to take your lordships and your ladyship to the regulations which come with the Consumer Credit Act that apply to default notices. It may be of assistance if your lordships and your ladyship aren't familiar with those regulations to just have a quick look at what has to be in a default notice. Well, it's in the authority bundle, and it's tab 2. Sorry, tab 3. This is the Consumer Credit Enforcement Default and Termination Notices Regulations of 1983, which I'll refer to as the default regulations.
Yes.
If your lordships return to page 24, which is Regulation 2. Regulation 2, subparagraph 2, any notice to be given by a creditor or owner. I'd like to invite your lordships and your ladyship to read that paragraph 2. So, just on that paragraph 2, we can see that there are a requirement for a statement that notice a default notice served under Section 87(1) of the Consumer Credit Act. And then we have information set out in paragraphs 1, 3, 6 and 8 of Schedule 2 and statements in Schedules 4, 5, 7, 9 to 13 of that schedule. Now, Schedule 2 begins at page 30. And this is entitled Form of Default Notice before a creditor or owner can become entitled, by reason of any breach by the debtor or hirer, to terminate the agreement, demand earlier payment of any sum, recover possession of any goods or land, etc. And so over the page, at page 31, the first requirement is a description of the agreement sufficiently to identify it, which, in my submission, the letters numbers, which I referred your lordships and your ladyship to earlier, doesn't make any reference to that. Those string of numbers and letters, which were found to be the basis of a default notice. So we don't have a description of the agreement sufficiently to identify it. Regulation Schedule 2, Paragraph 2 states it has to have the name and postal address of the creditor or owner, the name and postal address of the debtor or hirer. I do apologise. That's not actually that's not referenced in Regulation 2. So it's Paragraph 1, description of the agreement. Paragraph 3, which is over on page 32, which says a specification of A, the provision of the agreement alleged to have been breached, B, the nature of the alleged breach of the agreement, specifying clearly the matters complained of.
Actually, I think it is 2 is part of it. It's one. Regulation 2(2)(b) requires that the notice contains the information set out in paragraphs 1 to 3. So 2 is.
Yeah.
Oh, 1, 2, 3. I do apologise. Thank you, my lord.
Anyway, nothing is going to turn on this. There are a good many paragraphs setting out quite a lot of detail, and obviously, if simply the one line with the what appear to be letters and dates and so on, if that one line had been all that was sent to the consumer, of course, that would nowhere near comply with the regulations. In a sense, the detailed paragraphs don't matter. Your point is more general. You can't or the DDJ should not have been allowed to infer the provision of all this detail in exact form. You can't tell that from the fact that a line of code, as it were, is on the log.
Precisely.
You don't necessarily have to particularize whether it has to give the address and so on. All right, got that point.
I'm obliged. There's also a requirement for 14 days as well. 14 days arises from Section 87(1) to give at least 14 days notice from the date it's received by the consumer. And often that's where some of these default notices fall down. They don't give sufficient time. And I set
at least 14 days before what?
14 days before they can take the action which is set out in the default notice, i.e. terminate the agreement, demand the repayment of the full sums, etc., etc. Paragraph 87 is included in the authorities bundle at tab 1.
Section 87.
Section 87.
Yes.
Yes. And that is page 15.
I think it's 88 too.
And yes, 88. It's paragraph, section 88, subparagraph 2, a date specified under subsection 1 must not be less than 14 days after the date of service of the default notice. So, as your Lordships and your Ladyship have seen, there's a huge medley of detail which is required in that default notice, which wasn't before the court, and which was inferred from that simple line of letters and numbers. And all of that, those submissions I've just made are summarised right through to paragraph 17 of my skeleton argument, so I'll give you reference there.
Yes.
So one of the main, turning now, unless your Lordships and your Ladyship have any questions about those submissions, I'd like to turn now, if I may, to the best evidence rule.
Yes.
At paragraph 19, I've given a quotation from Lord Justice Jonathan Parker in the case of Masquerade Music Limited and others versus Springsteen, 2001 EWCA CIV 513. I just invite your Lordships and your Ladyship just to read that extract. I can take your Lordships to the case if required.
Probably one should read paragraphs 77 to 80 as a whole, as I did yesterday. Tab 21.
Page 317.
So 77 to 80 and 85, isn't it?
Yes, my Lord. Lord, obviously that's an indication that the best evidence rule is, if not on its deathbed, then it is already gone. My main submission about this point is the lack of primary evidence and no reason for it. And that is the quotation at paragraph 80. And Lord Justice Jonathan Parker states, at paragraph 80, for my part, I would not even recognise the continuing existence of that remaining instance of the application of the old rule. In my judgment, the obligation of a party who has a document to produce the original evidence is founded not on any rule of law, but is simply a reflection of the fact that a party to whom a document is available will, by reason of that very fact, be unable to account to the satisfaction of the court for his non-production of it when inviting the court to admit secondary evidence of its contents, with the practical consequence that the court will attach no weight to the secondary evidence. And the point in this case, and why this is so relevant, is that it was asserted throughout that this was a copy of the default notice, not a reconstitution. So, because there is no original evidence, primary evidence, but the claimant says they have it, but they don't produce it, we don't even get to the secondary evidence because there's no explanation.
Well, I'm a bit puzzled about that because it is and was your case throughout. They didn't have a copy. That was your point from the start. Not a copy.
Yes.
Yes. But you say that one and the same time, the court is supposed to accept that they don't have a copy, but hold against them the fact that they do. Because this rule depends on the party having the document. You say they don't.
My submission is there's been no explanation as to why it's not. We suspect they don't have it, or we may suspect it's not compliant. But we can only suspect because we don't have that information available to us. That is in the hands of PRA to produce that evidence.
I'm just wondering what you say that this principle is, because on the face of it, the point is, here's a party who has the document, doesn't produce it, and therefore the court is going to give no weight to secondary evidence. As I understand at the moment, the only evidence as to what PRA had that you are relying on is what they said in their disclosure statement. And that was a copy.
If I may, I'll take your lordships through the document so that we can see.
That would be helpful. Thank you.
Yes.
So when the respondent says there's been no change, let's start with the core bundle, if we may. And if we can go to tab 10 of the core bundle, these are the particulars of claim at page 94, sorry, 74. So these are the particulars of claims that we faced. Paragraph 22 it states a copy of the default notice sent by MBNA is exhibited at Appendix 10 to these particulars of claim.
Where is Appendix 10?
It's the document which was before Deputy District Judge Simpson, which was the Reconstitution.
Okay, can you show us Appendix 10 to the particulars of claim as served?
I don't have that in the bundle, but I can obtain that. But it is essentially the only document which was given was the reconstituted version, which was supplied to Deputy District Judge Simpson. Is your lordship asking to see a copy? What copy was before the judge?
Yes. After several years in this building, I'm coming to learn that the more bundles of documents there are in a case, the more likely it is that the few which matter will not be found anywhere in the document. If anybody has a reference to this document, I'd be grateful to have it.
The
It's
notice of
tab-
default. My lord, the notice of default.
Yes.
The supplementary appeal bundle, page 48.
Thank you. Right, so this was Appendix 10 to the particulars of claim.
Right.
Thank you.
11 of the core bundle, we have the defence, and at page 81, paragraph 12, that was the denial that it was compliant with Section 88 of the Consumer Credit Act. That's paragraph 12, page 81.
Yes.
And then we have a reply, which is at tab 3 of the supplementary bundle. And that begins at 8. The relevant page is page 42. So this is a supplementary bundle, tab 3, which is the reply to defence, page 42. Paragraph 15D. So in this reply, there is a mention of reconstitution about the credit agreement. So the averment that the remainder of the credit agreement is not a copy, but rather a reconstitution is denied. So the defendant the claimant and his respondent, rather, was aware about the issue of reconstitution at this time, but only in relation to the credit agreement. And if we turn on to page 44, paragraph 17 deals with the default notice, and nothing is said there. There's an opportunity there to say, oh, it's not a copy, it's a reconstitution, but it's not. There's no mention of reconstitution there. So that's the case that we were facing. And then at tab 9, we have the disclosure list. So that's still within the supplementary bundle. Tab 9, page 159, and it's entry 26.
Sorry, I'm slightly behind you. Could you give me that reference again?
Yes, so we're still in the supplementary bundle. It's tab 9, page 159. This is the standard disclosure given by Mr. Stephen Glassborough for the claimant, PRA. Page 159, entry number 26, which is about 2/3 of the way down the page.
I just noted at page 161, the originals were said not to be in the respondent's control. The originals of correspondence dispatched.
Well,
I mean, it looks rather imperfect, this list, as so often they are, because what you've just identified is not described as a copy, is it? That's your point.
Precisely.
But at the same time, it's their case that that's a document that was dispatched, and they say the originals are not in their possession and control.
With respect to the originals, but the copies that are retained and must be retained by MBNA, they've stated they have access to it on page 159. So they can't use a get-out clause on page 161 of the originals, because you don't have to provide the originals, because copies are kept by MBNA, the actual copies.
Yes. Well, of course, yes, of course. I mean, on their case, they send the original, as it were, the top copy, in the post to the borrower. But you say they, nobody imagines that page 159, paragraph 26, means we have the very piece of paper that we sent to the defendant. But what you say it means is we have the retained copy. There should be two identical documents, one of which is posted and one of which is retained.
Which is why one uses the word copy to mean an actual copy.
Yeah.
So,
can we just go back to the pleading you showed us on page 42 of this bundle?
yes, tab 3, page 42.
The averment that the remainder of the credit agreement is not a copy but rather a reconstitution is denied. That deals with a separate point, doesn't it? That the defence, it denies many things, but the paragraph 8D is a denial as to what the contents were of the application form which the defendant served in the first place.
It is quite right. It is a separate point. The reason why I draw it to your Lordship's attention is because the issue about reconstitution has been, the PRA are aware of reconstitution and what it means because they're referring to it in their reply to defence. So they can't simply say, "Oh, I didn't know it was a reconstitution." it's not a copy of the original. So we've
But the issue
discussed
of reconstitution was raised in the defence.
in relation to the credit agreement.
Yes.
So under section
Paragraph
7.
8C of the defence.
Yes, but not in relation to the default notice, because at this point, all we're dealing with is a copy, as far as we're aware, of the default notice. And there's nowhere in the reply, which is at page 44, any mention of this being a reconstitution.
Well, no, that wouldn't be the right place to make the point, would it? Because you haven't raised an issue about it in your defence. So if reconstitution was going to be relied on, it would be in the particulars of claim, not the reply. Reply is an answer to what you say.
Well, quite, but it's not in the particulars of claim either.
No.
It's not mentioned. It's
Your point about the reply is, I would suggest, not your best point, because it's a reply, not their claim. So all you need to say is their case was that they served a copy.
Precisely. I was only flagging that because it shows an awareness of what reconstitution is on the part of PRA.
Yeah. But anyway, your defence was you didn't receive anything.
Yes.
Whether it's one line document or a 10-page document, you didn't receive it, or seems to be.
Yes. Well, technically, that was raised as a defence. It actually forms part of the cause of action, because the service and expiry of a default notice, which is compliant with Section 87, is part of the cause of action.
Yeah, but it doesn't mean you have to prove what you say by way of denial, but you deny it.
But we deny, yes. But that's why we didn't give evidence at that point on that issue. We conceded that point. Mr. Goodinson didn't give evidence about receipt or not of the default notice.
But in just the same way as it was open to you to raise the question of whether or not the credit card, the credit agreement documentation was reconstituted, wasn't it open to you to raise the issue that the appendix to the particular claim was a reconstitution document?
Our basis was this isn't a copy. That's what we argued. This isn't a copy.
No,
That's the
but
case.
you're not answering my question. Was it not open to you to raise in your defence that the document that was appended to this particular claim was a reconstituted document?
No, my lady. And the reason being, there's no such thing as a reconstituted default notice. It simply doesn't exist. We can't plead something which doesn't exist.
Well, that's a matter of language, but if you say it wasn't a copy, did you have a case as to what it was?
We did, and we made those submissions to the judge to demonstrate that it wasn't a copy, because it had the wrong year on it. It mentioned the wrong regulator. Would your lordships and your ladyship want me to take you to the...
Well, I think he made the points in his judgment, didn't he? It was obviously, in another case, it would have been put forward as a forgery, because it was put on documents, on notepaper that didn't belong to the time that it purported to come into existence. But no one was ever suggesting it was a forgery. You were just saying it couldn't be a copy because it had features that demonstrated that it couldn't have been created at the time it was said to have been served.
Right. It's
Put
not...
another way, it's a reconstituted copy.
Well,
or reconstituted document.
I would prefer the phrase, my lord, a fresh document, because it's not. This is the issue. This is what we come on to, the issue of reconstitution, because reconstitution is only allowed under the Consumer Credit Act in one very specific circumstance, and now the respondent seeks to say that it's fine across the entire Consumer Credit Act industry and the Consumer Credit Act itself. Reconstitution, this is the problem that we have, is that it's just a different document. It's not a copy, which raises all manner of questions, which is who made this document? When was it made? What was their source of information? What manual points did they input into this data field? So many questions, but because we were told it was a copy, we didn't ask those questions. We normally would, if they'd said it was a reconstituted version, we'd say, well, where's your evidence? Who's made this document? When was it generated? What was their source of information? Where's their witness statement?
Yes, I understand that. But you also, anyway, your defence is you weren't sent anything.
Well, yes, we weren't sent anything. And in response, the claimant has to show that a valid and compliant default notice was sent
Yes.
and was compliant.
Right.
So if we return back to the supplementary appeal bundle, tab 10, we have the Part 18 request. So this is tab 10, beginning at page 162. So this is the claimant's Part 18 request for information and replies from the defendant. So page 162, at the top there, it states, of paragraph 8b of the defence, the remainder of the credit agreement documentation is not a copy, but a reconstitution. And they ask, what is the basis that you assert it's reconstituted? And that is set out below. So if the issue of reconstitution had been put forward by the claimant, we obviously would have taken a slightly different course at the trial and in our pleadings. And at page 164, again at the top of the page of 164, this is a question, question number 5. The full basis upon which it is pleaded that the default notice exhibited to the particulars of claim did not comply with the Consumer Credit Act 1974, section 88. And we simply state the obvious. We can't say how it doesn't compare because we don't have a copy of it. It does not comply with section 88.1a and 88.4a of the Consumer Credit Act. So both parties are aware about what reconstitution could mean, but the claimant isn't saying that they're copies of reconstitution. And nowhere in the pleadings, reply, or later, and nowhere in the skeleton argument or a respondent's notice from the respondent do we ever hear mention of reconstitution till we get to Her Honour Judge Clarke, in which Mr. Mantle made submissions.
Well, that's not right. The district judge uses the word reconstitution.
Yeah, sorry, my lady, it was from the claimant. I mentioned reconstitution in my skeleton argument at the trial and mentioned it in trial as an explanation as to why this is not a copy. And we looked at an NOD request, which was 2 years later.
So this is the trial in front of the district judge.
Mm-hmm.
You mentioned it in your skeleton argument.
As an explanation as to why this is not a copy, because our argument was, this isn't a copy. They're saying it's a copy, we say it's not a copy. And this is why.
So you used the word reconstitution.
I did.
At the trial.
I did.
And the judge accepted.
As an explanation, because it's not a copy. And that's where the phrase reconstitution comes from in the judgment.
And was it your case then that if that submission was accepted, that was the end of it?
Yes. It's not a copy. That should have been the end of the matter. But instead, Deputy District Judge Simpson went further and was asked to infer the existence of a compliant default notice and was taken by PRA to that particular readout of numbers and letters. So I wasn't trying to amend our defence or anything like that. I was simply trying to give an explanation to the judge why this isn't a copy of the original from the manifest errors that are on it, on the face of it. So what was given as an explanation for a failure of the claimant to prove their case was taken on board by the judge and changed, as it were, from, oh, I don't have a compliant default notice, to let's have a look to see what we can infer. And there was obviously no application to amend the particulars of the claim, and there's no reference to that in the judgment.
Did your grounds of appeal to Judge Clarke include a complaint that there had been a procedural unfairness?
The procedural irregularity.
a procedural irregularity before the district judge, in that you had to have been confronted in the end with a judgment that went beyond the issues that the district judge was supposed to be trying.
No, we did not.
That's what you're saying now.
Well, in response to the questions, I am explaining what happened.
I
And yes,
understand the context in which you're saying it, but
unfortunately, when one has an appeal where the main point is this isn't a copy and the reconstitution process is flawed, we didn't appeal on that grounds because we thought that was, well, it wasn't considered at that time, and it was considered that that was obvious and sufficient, as is the appeal before your lordships and your ladyship today.
Yeah.
It's obvious and sufficient. So one doesn't want to throw everything at a judge if one can avoid it. And in my submission on a simple point of law, there was no evidence upon which the Deputy District Judge could draw any inferences whatsoever. And when we're talking about, in the context of what we've just seen from the paperwork and the pleadings in relation to a copy as opposed to reconstitution, I wonder if I might draw your Lordship's attention to Cary and HSBC, which is within the authorities bundle, page 122. This is the case of Cary versus HSBC Bank PLC and others, which was heard by His Honour Judge Waxman QC, sitting as a High Court judge. And it was an in-depth determination of the requirements of Section 78. Now that's a slightly different section. I've set that out in my skeleton argument. But Section 78, well, Section 77 to 79 of the Consumer Credit Act, they're all in relation to information. You must provide copies of documents. When a consumer loses their contract, they might want to know what they originally signed up to, so they're entitled to make an application to the creditor to provide that information. And importantly, page 122, this is paragraph 57, and entitled Information to the debtor as to the type of copy provided. So it's tab number 8, page 122. Before I proceed, are your Lordships and your Ladyship familiar with this case, or shall I give a summary background?
No. If I could just read the head note. I think I've got an overview for myself. Yes.
Thank you. Yes, so this is just a detailed consideration of Section 78 Consumer Credit Act, which is governed by a different set of regulations. And the point that His Honour Judge Waxman QC made comes in 6 lines down from however as a matter of good practice.
Yes.
And so as not to mislead the debtor, it is clearly desirable that the creditor should explain that he is providing a reconstituted as opposed to a physical copy of the executed agreement. Which reinforces the point I was making about we're dealing with what we think is a copy. All we have to do is prove it's not a copy. And now we're dealing with a reconstitution. And of course, at no point until the appeal before Honour Judge Clarke does PRA then start making submissions that, oh yes, clearly a reconstitution, that's fine. I'll just return now to my skeleton argument, if I may, unless
Yeah.
you also have any questions about that. But we'll be returning to this case in due course from my skeleton. Page 6 is where my submissions about the reconstituted default notice begin. And I've explained, I'd just invite your Lordships just to read paragraph 25 and 26 and 27 of my skeleton, simply because that gives a summary of what's happening in Cary and HSBC.
Yes.
Obliged. My Lord and my Lady, if you'll be so kind as to turn to the authorities bundle, and we'll actually have a look at section 78, so we know what this is about and why this is very different to a default notice. So it's tab 1 of the authorities bundle, it's page 11. We have section 78 of the Consumer Credit Act. And it's entitled, section 78 is entitled Duty to give information to debtor under running account credit agreement. Subparagraph 1, the creditor under regulated agreement for running account credit within the prescribed period after receiving a request in writing to that effect from the debtor and payment of a fee of £1 shall give the debtor a copy of the executed agreement, if any, and of any other documents referred to in it, together with a statement signed by or on behalf of the creditor showing, according to the information which is practical for him to refer, the state of the account, the amounts, etc., etc. So this section is all about giving information to a consumer about what they signed up to. What's the current version of their credit agreement? Because obviously it goes through amendments. And that's what Cary was really considering. In Cary, the claimants were actually the consumers and the banks were the defendants. And there was it was put forward in two different ways by both parties, essentially. One is that Section 78 has a proof purpose behind it, and the other is that it's an information purpose. So, and that was considered in great length by His Honour Judge Waxman in Cary. And the final...
You might have thought the clue was in the heading to Section 78. But anyway.
Precisely, my lady. That's a duty imposed by the Consumer Credit Act. Section 87, which is on page 15, is not about a duty to provide information. It's need for a default notice. Completely different. In my submission, it's a different part of the Act. So Section 78 falls within Part 6 of the 1974 Act, which is matters arising during currency of credit or hire agreements. I set that in paragraph 29 of my skeleton argument for reference. And Section 87 I just invite your lordships and your ladyship to read paragraph 29 of my skeleton, just so you can see the point I'm making there. The point that the submissions I'm trying to make on this point is that there's a very strong difference between a duty to give information, which is allowed to be reconstituted from different sources, as per Cary and HSBC, and Section 87, which comes under default and the need to provide default notice. Different sections covered by different regulations. So default has the default regulations, and the copies of documents which are required by Section 78 are governed by different set of regulations. Those regulations are at tab 4. I don't intend to go through those, but simply to point out that the consumer credit cancellation notices and copies of documents, different set of regulations. And so when His Honour Judge Waxman was considering in Cary the proof purpose or whether it was information purpose, he gave an indication that it was for information only. Section 78 is a duty to give information. So it can't be used as evidence, shall we say, that the credit agreement's not compliant with the Consumer Credit Act. So the purpose of Section 78 is to provide information, and the purpose of Section 87 is a strict requirement to provide a default notice.
Yes, but the notice has to contain certain information. The purpose of the notice is to convey facts and information to the debtor. So how do you draw a distinction in principle, rather than one of language, between the function of the notice that's subject to the copies regulations and to Judge Waxman's decision and Section 87?
It's because of a reading of the Consumer Credit Act itself, and it's set out in my skeleton argument, this very, very point. And that's from paragraph 30 onwards. So Section 180 of the Consumer Credit Act, which I've set out there for convenience, but is at page 20 of the authorities bundle. So power to prescribe form, etc., of copies. So if I can take, it may be useful for your lordships just to have that at page 20 of the authorities bundle, because the distinction is very important and it is clarified by the statute itself. If I can refer your lordships to page 20 of the authorities bundle. In summary, if I may just get to the point, Section 78 is an exception which in Cary has determined that you do not have to provide actual copies. They can be reconstituted because of the wording and language of the regulations themselves. And if we look at Section 180, page 20, which says regulations may be made as to the form and content of documents to be issued as copies, of any executed agreement, security instrument, or other document referred to in this Act. And paragraph B of Section 180, subsection 1, says those regulations may authorise the omission from a copy of certain material contained in the original or the inclusion of such material in condensed form.
Isn't this dealing with those cases in which the Act imposes a duty on the creditor to supply a copy of the document, see subsection 2? Or have I got that wrong?
Precisely right, my lady. But
Right, so the Act itself imposes duties to supply copies of certain documents, and this regime is to deal with what those copies should look like.
precisely. And those copies regulations are separate to the default regulations.
So that means that the respondent can't rely on the copies regulations as a way of justifying what they did in this case. But it doesn't necessarily provide the answer to what the court can accept as evidence of service.
But also this is dealing with cases where there's a duty to provide a copy.
Yeah, precisely. And it's actually come to the crux of this argument.
So it doesn't apply to cases where somebody's trying to rely on a copy as evidence, or secondary evidence of something else, does it?
But my submission is that the Consumer Credit Act doesn't apply in terms of evidence, with the exception of Section 78, and reconstitutions are allowed. Other than that, the normal rules of evidence apply. Section 111, answering my lady's point just then, which is at page 18, allows for a copy of a default notice. This is page 18, section 111, duty to give surety, copy of default notice.
Yeah.
And that sets out when a copy may be provided and how.
No, it's a duty. That's the point I was trying to make in my question a moment ago. This regime is dealing with those cases in which the Act imposes a duty on the creditor to supply a copy of the document, and regulations regulate what will count as a copy for that purpose. But we're not dealing with a case where there's a duty to provide a copy in a particular form. We're dealing with a case where the creditor is saying, I haven't got the original document, O court, but I'm asking you to infer that what I sent was a compliant notice on the basis of this secondary evidence. So it's a different point, isn't it?
Well, it's only I make those submissions in reply to what the respondent is saying about it being fine to apply reconstitution across the entire Consumer Credit Act. And it doesn't apply, as Milady just pointed out, to Section 87 because there's no duty to provide a copy.
But that doesn't exclude that you might have a power to provide a copy. That's the point I'm trying to get across.
Which is Milady, yes, that's a point of evidence. But
yes.
The point I'm trying to make is that the Consumer Credit Act does not allow for reconstituted versions of documents unless it's under the duty which your ladyship was
What do you mean reconstitute? I mean, there isn't any dispute, is there, that the default notice which MBNA had to serve on Mr. Goodinson had to comply with the default notice regulation. The issue is whether the Deputy District Judge was entitled to find on the secondary evidence before him that they had proved that on a balance of probabilities. It wasn't a question of their sending him a copy. They had to send him a document which complied with the regulation.
at the time of default.
Yes.
Quite right, my lord.
Yeah.
So if that's accepted by the court, and I feel that it is, that I will
Well,
move away.
I'm not sure, because I think there's a fundamental confusion in this part of your argument. The fact that the Act imposes duties to provide copies in certain cases tells us nothing about the cases in which someone might, as a matter of evidence, seek to rely on a copy or a reconstituted document. It just doesn't help.
With respect, my lady, the reconstitution comes about as a result of Section 78. This is what allows reconstitutions. Section 78 allows agreements, because they have to be the current version, they need to be reconstituted from different sources. This is what Case and Cary was all about. And a detailed consideration of all the regulations in that, the judge concluded that it was just for information purposes and not for proof purposes.
But that's dealing with a different statutory provision. That's a statutory duty to provide a a copy of the agreement so that the person knows what they've signed up to in case they've lost it.
Precisely. All I'm saying is that there's been a creep, shall we say, of what is allowed under Section 78, which is you are allowed to reconstitute the documents, you are allowed to reconstitute the credit agreement. That's allowed under Section 78.
Isn't Cary simply authoritative, this part of it, simply authoritative for the proposition that the word copy embraces a copy that has been reconstituted as well as a true copy in the context of that particular statutory provision?
With respect, that's not quite the conclusion that is made in Cary. It must be a true copy, but a reconstitution is not a true copy. This is the point I'm trying to get. A reconstitution is a process whereby someone goes away and gathers information from different sources, puts it in a piece of paper and provides it. That's a reconstitution. That's different to providing a copy of a document, which has to be a copy. And it has to be a true copy, according to the regulations and the decision in Waxman. And this was not, even if we accept the inference, this wasn't a true copy.
But why does it matter? I'm sorry. I think it's my fault. I'm just not following this part of the argument at all.
Milady, I think I'm probably just not explaining it very well. I do apologise for that. The issue that I'm trying to address is there is a specific power to reconstitute documents from different sources under Section 78 when you're providing information to a consumer. That reconstitution process does not extend beyond, as my lady pointed out, those duties under Section 78 to give information. Which is why I'm trying to make the submission that there's no such thing as a reconstituted default notice. Reconstitution is only allowed for Section 78, and that is a result of Cary.
All right, well, I've got the submission.
All right. And anything else from Cary and HSBC?
If I may just check my skeleton argument. The reference at paragraph 34 of my skeleton argument, page 9, I make the submission there that even if we accepted the respondent's submissions that inference is allowed to be made about the existence of statutory documents, this was not a true copy. So,
sorry, you get the phrase "true copy" from the judgment in Cary. Is that right?
Actually, it comes from the regulations themselves, from the copies regulations.
Right. Okay. Well, that's fine. I'll just note that that's where the phrase comes from. Thank you.
It does appear in that judgment, but it's also specifically set out
All right.
in those regulations. So my primary submission, which your lordships have already got, is that there's no such thing as a reconstituted default notice. We just look at the normal rules of evidence. So here we turn to the question of what evidence was before the judge and what could be relied upon. And in, my submission is fairly straightforward. We've seen what was before the judge, a simple line of letters and numbers. And from that, one cannot infer compliance with a statutory notice because it didn't have reference to the wording that was required, and we went through in some detail what the regulations require to be set out in a default notice. None of that is there. And of course, there was no evidence as to how these were compiled, and neither counsel could assist, as Deputy District Judge Simpson pointed out, neither could assist with what these meant. So it really was just a case of speculation as to what this document is and what the contents are thereof. And from that, the judge suddenly comes to the conclusion that a whole compliant default notice was sent at the time on the basis of those numbers and letters. And that, as a fundamental rule of evidence, that can't be right.
Well, it wasn't just the numbers and letters. Surely it was also the document that was appended to the particulars of claim.
Well, my lady, it can't be...
Which the district judge used to draw inferences. So the district judge used the lesser numbers to draw inferences about the document that was appended to the particulars of claim.
This is where we hit a logical fallacy, or
Right.
a logical problem. One can't say, this is not a copy of the document, so I don't know what the document contained, but now I'm going to infer what it says from a non-copy. That, in my submission, is logically incorrect. One cannot say, the evidence isn't before me, but I'm going to look at something that definitely isn't a copy to see what was in the original.
Well, can you encapsulate the rule of the law of evidence that you say was violated in this case? Because you've just said it's contrary to fundamental rules of evidence, and I just haven't really grasped what the rule of evidence is that you say was violated.
Perhaps I was putting that a little bit strongly, if I may. Well, when looking to secondary evidence, my submission is you have to first get past why is there no primary evidence? Why does it not exist? Because you don't look at secondary evidence first. One needs to, as a matter of logic, start with the primary evidence, and if a copy is not supplied, why is it not supplied? It may be there are cases where documents are lost in a fire, etc., and that is a good reason for relying on secondary documentation in those cases, where an explanation is given, and evidence is given as to why the original is no longer held. That is not the case here. Simply turning up at court and saying...
Is that the point, that there was no evidence before the district judge as to why the original document wasn't, the original copy, as it were, wasn't being produced?
Absolutely. And not only that, I know your Lordship's rejected the application today, new evidence, but there's been no explanation at any point throughout these proceedings as to where the original is or why it wasn't produced. And Her Honour Judge Clarke found in the appeal that this clearly was not a copy of anything.
Well, we've been into this original stuff before. On their case, the original had been delivered to your client shortly after it was created, and the copy that they held on their records was retained. That was their case, wasn't it?
That was the case we thought we were meeting, yes, and that they would provide a copy. They did not provide a copy. And that obviously raised these questions.
So the inquiry into where the original was would have resulted in them saying, as they did say, you had it. Don't know what happened to it then. We've sent it. But what you're talking, I think, about is the copy held originally by the original lender, MBNA, that wasn't produced.
Well, these documents, obviously, when they're produced, they're simply printed off. So yes, the original, or a copy of the original, goes to the debtor, but effectively that electronic copy is kept by MBNA or whoever the creditor is. So if they want to produce a copy, fine, it's a copy. And under the civil procedure rules, the standard rules as to what a copy is and what a copy is not would apply. And in this case, because it's not a copy, it's not a document we can rely on at all, because we don't know where it's come from, who created it, why they created it, where they got their information from, nothing. And so, yes, quite right, the first hurdle is no primary evidence, no explanation for primary evidence, therefore shouldn't look to the secondary evidence. But in any event, even if we could look to the secondary evidence, it was insufficient in this case to form the basis of the decision of Deputy District Judge Simpson, which was upheld by Her Honour Judge Clarke. You simply can't infer a two-page document from one row of letters. It's my principal submission. I'm just checking the remainder of my skeleton.
Of course, yes. Please do.
Other than the submissions in my skeleton argument, the final point I would like to make in relation to this, aside from, yes, it is a question of law, is the consequences of what might happen. And this gives carte blanche in my submission for creditors or debt purchasers to turn up at court, not produce their evidence, not explain why they don't produce their evidence, and then seek to rely on questionable secondary evidence to support what is a fundamental part of their claim, part of their cause of action. And it feels a bit surreal to be asking the Court of Appeal to uphold a basic principle that a claimant must prove their case. But in summary, that is what we're asking, is that they must prove their case. And in order to prove their case, they must provide a copy of the document so that they can show it's compliant. Without that, they can't go any further.
Right.
And this does leave a hanging question, which is why are these default notices not being produced? Fortunately, that's not a
I suppose
question
the
we can answer.
Deputy District Judge might have said, I'm not satisfied that you ever sent a document and dismissed the claim. That might well be unappealable. But you say he's bound as a matter of law to reach that conclusion.
Yes, because the exercise being carried out by the Deputy District Judge was comparing a document to the regulations to see if it's compliant.
I see that.
If there's nothing to compare them with, one can't go any further.
Well, there's an explanation of the genesis of the document in Mr. Glassborough's statement. He says in paragraph 8, he refers to the document attached to Appendix 10. He says the claimant has obtained this copy from MBNA, pursuant to the terms of the assignment of debt. The copy is a reprint of the document that was stored electronically by MBNA, and I've seen nothing which suggests that it is not a faithful reproduction of the original.
My lady, that witness statement was not before the judge when considering this point, because we objected to Mr. Glassborough giving evidence about matters outside his own knowledge for the very same reason that the respondent objected to our witness giving certain evidence. And the judge accepted that. And so there was no evidence called from Mr. Glassborough, no chance to cross-examine, etc.
Right.
And we would have had a great many questions about that process of where these documents are coming from, who's creating them, and for what purpose.
Sorry, what? The witness statements of Mr. Glassborough and Mr. Goodinson, Supplementary Appeal Bundle 1 and 2, you say were not in evidence before the Deputy District Judge?
So they were in evidence for the purposes of the trial, but for the purposes of this specific point, the judge accepted submissions on both sides that because no one can speak to these documents, we can't give evidence on that. Neither party give evidence on it. And so there was no witness statement as to what happened, how this was generated, etc. And Mr. Glassborough never gave evidence and was never cross-examined on that point because he couldn't speak to it. So also he has to set out the source of his information.
Well, presumably he spoke to somebody at MBNA, but we don't know. All right.
So why are we being shown these? You say that
No, it's my fault. It's my fault that I raised it.
They are in evidence for the trial which has yet to take place, but the trial judge, Deputy District Judge, held that he shouldn't look at them for the purpose of deciding what he did decide.
Over the adjournment, which might or might not be happening shortly. I will endeavour to find the precise part of the transcript where that's dealt with, so that your lordships can be satisfied the evidence of Mr. Glassborough was not considered by Deputy District Judge Simpson. Other than that, that closes my submissions. So unless your lordships or your ladyship have any further questions.
Well, I think we'll break off at this point then and return at 1:55.
Thank you.